Okay, this is going to be your 1 minute 180 lit for practice. And let me give you some words that come out. You have a lot of proper names, okay? So remember, this is just 1 minute practice at 180. Here we go, 1 minute 180 before your mock. Plaintiff FERC is a separate agency of the U.S. with authority to license and regulate hydroelectric generating facilities. The Commission brings this action pursuant to the authority conferred by the Federal Power Act. Defendant Fred H. McDonald, trustee of the Milford Elm Street Trust, is the licensee of a generating facility that's located on the river in Hill County, New Hampshire, that is known as the Pine Valley Project. McDonald is being sued in his role as licensee. The Milford Elm Street Trust has been the owner of the project since 1979. Mr. David Blackmer is the sole beneficiary of the Milford Elm Street Trust Fund, and he is also the owner and president of a company known as Earthworks, Inc., which did all of the work at the project in 1994-1995. Mr. Blackmer was acting on behalf of the defendant for all work at the project described below. The group has 5 local offices, and each one is headed by a local leader who was once. And then we have on your 180 lit Clark County Court, and that's it. I do see October, capitalize that as well. And that's it. This is going to be your 180 lit for your mock for 5 minutes, okay? This is an appeal from a judgment of the Clark County Court rendered on July 9, 1991, upon a verdict convicting defendant of manslaughter in the 2nd degree, and from an order of said court entered October 20, 1991, which denied with the hearing a motion by defendant for an order vacating the judgment of conviction and granting a new trial. This case involves the death of the defendant's 4-month-old son on October 12, 1986, at approximately 9 a.m. as a result of massive head injuries. Immediately after the infant's death, the defendant was questioned by the police, following which he was arrested and later indicted for the murder of this child. The testimony adduced at the trial discloses that the defendant's wife brought the child to a doctor the previous evening at about 8 p.m. On that evening, the doctor found the child was suffering from a heavy cold. At that time, the doctor performed a complete physical examination of the child and found no evidence of face or head injuries. Later that night and throughout that night, the parents were alone with the child, and around midnight, only the defendant was with the child for a few minutes. The child was crying when the mother left him alone with the defendant those few minutes, but when she returned, she found the child unconscious and spasmodic, exhibiting symptoms of a head injury. The defendant admitted striking the child during this time and also admitted losing control while doing so. The child died the next morning with fresh, multiple injuries on the head and face. Medical experts testified that such injuries were about 8 hours old and would be caused by multiple blunt trauma, such as hitting with fists. There was also expert medical testimony that the child would become unconscious almost immediately after such injuries were inflicted, and that death would occur within 7 or 8 hours thereafter without the child regaining consciousness. On this record, there can be no doubt that the defendant's guilt was established by overwhelming proof. The conflicting testimony offered by the defendant, including any conflict in the medical testimony, simply created factual issues for the jury's determination, giving consideration to the credibility and relative weight of the testimony of the witnesses. Since there is ample evidence to sustain the jury's verdict, we may not disturb it. The defendant based his motion for a new trial on a claim of newly discovered evidence. A motion upon such ground is a statutory remedy and may be granted only in the second or sound discretion of the court. The statute provides that a judgment of conviction may be vacated where new evidence has been discovered which could not have been produced by the defendant at the trial, even with due diligence on his part, which is of such character as to create a probability that had such evidence been received at that trial, the verdict would have been more favorable to the defendant. The test thus enunciated, which has been approved and followed for determining the sufficiency of the new evidence, requires that 1. It must be of such nature as would possibly change the verdict if a new trial would be granted. 2. It must have been discovered since the previous trial. 3. It must be of such nature that could not have been discovered before the trial by the exercise of due diligence. 4. It must be material to the issue. 5. It must not be cumulative to the former issue. 6. It must not be impeaching or contradictory of former testimony. On this record, it is clear that these criteria have not been satisfied. The defendant contends that the affidavit of his wife and of a doctor obtained after defendant's conviction disclosed newly discovered evidence sufficient to warrant granting a new trial. Testimony is sought to be introduced in order to form the basis for the expert medical opinion regarding the existence of the battered child syndrome on the part of defendant's wife. There is no proof before us, however, bearing directly on defendant's innocence. At best, this is an attempt to establish by purely circumstantial evidence that the wife may be a batterer within the meaning of the battered child syndrome, but such evidence could not be considered as proof that the defendant did not beat and inflict the injuries resulting in this child's death. In order to serve to clear the defendant from being guilty in this matter, a jury would be required to conclude from the evidence that this is a case involving the battery syndrome. The child, despite the weight of the evidence establishing the guilt of the husband. Furthermore, the argument made on this motion was fully presented on the trial and rejected by the jury. Defense counsel knew at the time of the trial that defendant's wife was alone with the child before the defendant came home on July 8, and that defendant's medical expert placed the time when the injuries were inflicted at a time when the child was alone with defendant's wife. Counsel for defendant was also aware of several implausible explanations given by defendant's wife for injuries sustained by the child prior to this time, indicating a possibility that she may have been responsible for the child's death under the battered child syndrome theory. It is clear, therefore, and then we have 1 minute at 200 jury charge for warm-up. You should avoid radio or television broadcasts or newspaper articles that might discuss this trial. The only information that you are to receive about this case is when you are sitting here in the courtroom in my presence and in the presence of the defendant, and all of you are together. You are not bound by, and in fact, you should ignore any opinion that you think I might have expressed or any opinion you think the attorneys might have expressed concerning the guilt or innocence of the defendant. The credibility of the witnesses, the weight of the evidence, any facts proven by the evidence or inferences that you could draw from the facts. Also, the questions which the attorneys put to the witnesses are not evidence. It is the answers that are the evidence. You should not speculate that a fact may be true merely because one of the lawyers asks questions which suggests or assumes that a particular fact is true. I myself may ask some questions of a witness. The same thing is true of a question that is asked by a judge. Also, an answer given to a question asked by a judge has no greater weight. And then you have on your 200 jury charge for the mock, proper names, you have Commonwealth, one word. Let me make sure there isn't anything else. Make sure you capitalize it, one word. And that's all I see, okay? This is going to be 200 jury charge for your mock for 5 minutes. In doing this, I shall be reading from the written charge to make certain that what I'm telling is in accordance with the law and is standard and uniform. I advise you of that because it is almost a typical and understandable tendency not to pay attention to somebody who is reading to you. But it is very important now in accordance with the law of this Commonwealth. I give this as a warning and I ask you to pay attention, and I now know, if you understand, that what I'm about to say, probably for less than the next half hour, provides you with the tools that you will need to make your decision in this case. You will apply only the law to which I instruct you. You will not apply any law which you know or think you may know. If you wish instructions in the law, or if you wish clarification of those instructions, then you may, through your foreperson, send an appropriate written request. It is not possible to decide all questions of law, and you must accept and follow my instructions. You are the judges of the facts. It is not for me to decide what the true facts are concerning this defendant. You, the jury, are the sole and only judges of the facts. It is your responsibility to weigh the evidence, and based on that evidence and the logical inferences which flow from that evidence, decide the facts which apply as you find them, and then to decide whether the defendants have or have not been proven guilty of any of the charges. In determining the facts, you are to consider only the evidence which has been presented in court and the logical inferences which you have derived from that evidence. You are not to rely upon supposition or guess which are not in evidence. You should not regard this as any evidence, even if it is uncontradicted. Your determination of the facts should not be based upon sympathy for or prejudice against the defendants or the crime, nor on which attorney made the better speech, nor on which attorney you liked better. In my instructions, I may, if I do at all, refer to some particular evidence. I don't propose to refer to all of the evidence, but I will leave this to your recollection. It is your recollection and yours alone that governs. You are not bound by my recollection, nor are you to conclude that any evidence which I call to your attention or which counsel has called to your attention is the only evidence which you have to examine. It is your responsibility to consider all the evidence that you believe material in deliberating upon your verdict. The fundamental principle of our system of criminal law is that the defendant is presumed to be innocent. The mere fact that he was arrested and they were arrested and charged with crimes is not evidence of guilt. Further, the defendant is presumed to remain innocent throughout the trial unless and until you conclude, based upon careful and impartial consideration of the evidence, that the Commonwealth has proven them guilty of the charges made against them. It is not the defendant's burden to prove that he is not guilty. Instead, it is the Commonwealth that has the burden of proving each and every element of the crimes charged, and that the defendants are guilty of these crimes beyond all reasonable doubt. Some persons accused of a crime are not required to present evidence or to prove anything in their own defense. And the fact that the defendants did not take the witness stand in this case may not be held against them. If the evidence presented fails to meet the Commonwealth's burden, then your verdict must be not guilty. On the other hand, if the evidence proves beyond a reasonable doubt that the defendants are guilty of the crimes charged, then your verdict should be guilty. Although the Commonwealth has the burden of proving that the defendants are guilty, this does not mean that the Commonwealth must prove its case beyond all reasonable doubt or to a mathematical certainty, nor must it demonstrate the complete impossibility of innocence. A reasonable doubt is a doubt that would cause a reasonable, careful, and sensible person to pause, hesitate, or refrain from acting upon a matter of highest importance in his or her own affairs or as to his or her own interests. A reasonable doubt must fairly arise out of the evidence that was presented or out of the lack of evidence presented with respect to some element of each of the crimes charged. A reasonable doubt must be a real doubt. It may not be an imagined one, nor may it be a doubt manufactured to avoid carrying out an unpleasant duty. So, to summarize, you may not find the defendant guilty based upon a mere suspicion of guilt. The Commonwealth has the burden of proving the defendants guilty beyond a reasonable doubt. If the Commonwealth has met that burden, then the defendants are no longer presumed to be innocent and you should find them guilty. On the other hand, if the Commonwealth has not met its burden, then you must find them not guilty. You must consider and weigh the testimony of each witness and give it such weight as, in your judgment, it is fairly entitled to receive. The matter of credibility of a witness, that is, whether his or her testimony is believable and accurate in whole or in part, is solely for your determination. I'll mention some of the factors which might bear upon the determination of whether the witness has any interest in the outcome of the case. The behavior of the witness on the witness stand and his or her demeanor, his or her manner of testifying, and whether he or she showed any bias or prejudice which might color his or her testimony. The accuracy of, and we'll get ready for your Q&A. This will be 1 minute at 225 Q&A for practice before your mock. And do you remember what you did when you got there?
Yes, sir, I do.
What did you do?
I fixed lunch for my husband, and while he was eating lunch, he told me that he made a trade with the man about selling the land, and he was going to take it. He was going to bring the money, the down payment, that night or the next morning.
How long had Mr. Turner been talking with this fellow about selling this land? Do you know?
Not exactly. I believe it was 2 or 3 weeks, though. He was in the Air Force.
Now, after you fixed your husband's lunch, what did you do? Do you remember?
Yes, sir. We discussed the money, and we were going to take that money and buy a car for Christmas. That was Tuesday. Wednesday, we were going to go Christmas shopping and look at cars. And I said, well, I'll go ahead and do my laundry. And I put 2 loads of clothes, and it was clear enough and warm enough for them to dry on the line. I put them on the line. My husband was tinkering with the tractor out beside the garage.
Do you have a garden out there?
Yes, we did. We have better than half an acre.
What else do you remember? And then you have on your 225 Q&A, Trooper Wilkins, Illinois State Police, Sangamon County, Springfield, Illinois, State Police Academy, Springfield, Interstate 55, Williamsville, Memorial Hospital, and Gurnee comes out. And this is going to be 225 Q&A for 5 minutes for your mock. And it does start at the very beginning. Would you please indicate what you do for a living today, Trooper Wilkins?
I am Assistant Supervisor of the Illinois State Police.
On or about July 14, 1988, what was your job duty on that case?
Patrol officer patrolling the interstate area in Sangamon County near Springfield, Illinois.
What kind of training had you had in order to become a trooper performing those duties on July 14?
35 months of training at the State Police Academy in Springfield. Approximately 6 weeks of on-the-job training after graduating from the academy.
How long had you been a patrol officer prior to July 14 of 1988?
I began working that area in December of 1987.
And how many times would you estimate between December of 1987 and July 14, 1988, have you been driving southbound on Interstate 55, say half mile north of Williamsville, where this accident took place?
I couldn't even estimate that figure.
Would it be in the dozens?
Far more than a dozen.
Hundreds?
Possibly, yes.
On the date of the incident, July 14, 1988, did you have an opportunity to come upon an accident site involving a motorcycle?
Yes, I did.
Can you approximate for me, even without the police report here, about what time you came upon the accident site?
It was in the afternoon. I couldn't give you a time. Late afternoon. The sun was still out and shining.
Okay, what did you see when you arrived on the site?
When I arrived on the site, there were a group of people standing on the southbound right-hand shoulder of 55 in the area of the accident, and there was one subject laying on the ground or on the paved portion of the shoulder at that site.
And did you go over and talk to somebody when you got there?
Yes, I did.
And was it the person who was leaving on the ground, or was it one of the other individuals who was in this group or of people?
I can't remember at this time.
And did they say anything to you as to how the accident took place?
Not at this time, no.
How did you find out how the accident took place?
As I recall, I was able to interview the driver, or the person that I later determined to be the driver of the motorcycle, when he was at Memorial Hospital in Springfield, Illinois.
You didn't talk to him that you can recall at the scene of the incident then?
Not other than about his injuries and just trying to get him to calm down so that he wouldn't injure himself further.
Was he in some sort of an agitated state at the scene?
It wasn't an agitated state, but anyone tends to want to move around and ask questions. And since he had been in an accident of this type, I just wanted him to sit still so that just in case there was a possibility of aggravating the injury, he would not do so.
Okay. About how many other people besides the injured parties were standing on the right-hand shoulder? About.
Prior to the arrival of the police, there was an ambulance that responded. Prior to the arrival of the ambulance, I would estimate that in addition to myself and 2 other state police officers, making 3 people, there were probably 6 or 7 people there, the state troopers included.
I am sorry, 6 or 7 others, including the state troopers?
Yeah, total of, say, 6 or 7 people there.
So perhaps as many as 4 or 5 others besides the state troopers?
Yes.
And who were the others, the 4 to 5 others besides the state troopers? Were you able to determine whether or not they were just passing motorists in other cars, or who were they?
As I recall, there was one individual there who was attempting to assist the victim or aid the victim with his injuries. The other 2 or 3 people were there passing motorists. The person who was aiding the victim with his injuries was also a passing motorist.
Okay, when you interviewed the driver of the motorcycle at Memorial Hospital, do you recall what it is that he said to you there?
I can't recall specifically, no.
Can you give me your best recollection of what he said?
I asked him what happened to him, and he said that for some unknown reason, he had lost control of his motorcycle. As I recall, I think he said he hit a bump.
In the Memorial Hospital medical records, the driver of the motorcycle stated that he apparently caught his tire in a gap in the pavement and had lost control. Do you recall whether or not he said anything about catching his tire in a gap in the pavement?
I don't recall that statement, no.
You don't recall that he made any statement like that?
I don't recall. No, I don't recall.
Okay, let me maybe rephrase the question so I understand the nature of your answer. Do you recall that he didn't say that, or do you not recall whether he said it one way or the other?
The latter option.
You don't recall whether he said it one way or the other?
Yes.
Okay. Is there anything else that the driver of the motorcycle had said to you at Memorial that you can recall?
No, sir, there wasn't.
When you found him laying on the pavement, were there any injuries that were visible to you?
Yes, there were.
And can you describe what injuries you saw?
The injury that was most predominant and that captured my attention was he had injuries to his face and head. I believe he had a cut on his skull or high part of his forehead. It was bleeding quite a bit.
Had he been wearing a helmet?
No, he had not.
Did you see blood on his face or head?
Yes, I did.
On both or which?
There was blood on his head and face.
How did he leave the scene? Was he ambulatory when he went into the ambulance, or did they put him in on a backboard?
As I recall, they secured him on a backboard, put him on a gurney or the portable type of stretcher they had, and placed him in the ambulance.
Did you make any determination or did you make any inquiry as to whether or not he had been drinking at all prior to this incident?
An inquiry, no. A determination, yes. I was.
Okay, well, that concludes your mock for today. Have a good day and good luck, okay?